Your Worship, I confirm my learned colleague has granted us the undertaking to provide us with the officials' full names, rank, and superior contact details, Your Worship. So we'll take it further from there, or at a later stage we will deal with the matter extensively during the bail.
Mr. Chair, you may proceed.
Coming to the issue for today, Your Worship, there are 2 or 3 issues the state intends to bring to the attention of the court. Your Worship, on the last court appearance, the court made a finding against the state in terms of which the state was ordered to furnish the defense with the statement of accused number 1. And subsequent to that, the DPP decided that they will appeal that decision. The court was requested to furnish reasons for its judgment, and the DPP is grateful for that. The court has provided us with the reasons. However, during preparation of the papers for the appeal, it was discovered that the reasons furnished does not comply with the provisions of section 310, which deals with section 310 of the Criminal Procedure Act, which deals with appeals by the state. We then decided to write back to the court to request the court to furnish the case with, to furnish the state with a stated case. Basically, the misunderstanding which occurred earlier was that we requested the court to provide reasons instead of having requested the court to furnish us with a stated case.
So the state's request now is that the court should furnish the NPA with a stated case.
Correct, Your Worship. I filed the request with the clerk of the court today. I have a copy of the request which I made to the court. I believe the clerk of the court will give the court our request. I also have copies which I may furnish to the defense for their information. Your Worship, as soon as the state receives the stated case, it will proceed to file the notice of appeal. The next issue is with regard to the bail application, which the accused indicated it intended to apply for. Your Worship, the Director of Public Prosecutions has issued a written confirmation in terms of section 60, subsection 11, capital letter A, small letter A, to the effect that the accused are going to be charged with a Schedule 6 offense. And furthermore, that the bail application will be conducted at the regional court. I therefore hand in the confirmation to the court for the record as issued by the DPP. If it pleases the court, I may read the contents to the court.
You may proceed.
It reads as follows. In the matter between the state versus Zacharia Olivier, Andrea Rudolf and William Musora, confirmation in terms of Section 60, Subsection 11A of Act 51 of 1977. I, Mukali I.V. Tenga, Director of Public Prosecutions, Limpopo, Polokwane, in terms of Section 60, Subsection 11, capital letter A of Act 51 of 1977, do hereby confirm that Zacharia Olivier, Andrea Rudolf, William Musora are to be charged with at least the following offenses. 1, 2 counts of murder, read with Section 51, Subsection 1 of Act 105 of 1997. 2, attempted murder, read with Section 51, Subsection 1 of Act 105 of 1997. 3 counts of defeating the cause or administration of justice. 4, contravening of Section 3, read with Sections 1, 103, 117, 120, Subsection 1A, Section 121, read with Section 4, and 151 of the Firearms Control Act 60 of 2000, and further read with Section 250 of Act 51 of 1977, unlawful possession of firearms. 5, contravention of Section 90, read with Sections 1, 103, 117, 120, Subsection 1, capital letter A, Section 121, read with Section 4, and 151 of the Firearms Control Act 60 of 2000, and further read with Section 250 of Act 51 of 1977, unlawful possession of ammunition. 5, contravention of Sections 5, 9, capital letter 1, and 9, capital letter 3, read with Sections 1, 24, Subsection 1, A, Section 32, Subsection 2, Section 42, Subsection 1B, in open brackets 19, Roman figure 19, and Roman figure 8, and Section 49, Subsection 1A of Immigration Act 13 of 2002, entering or and remaining in the country without valid permit, accommodating or harboring an illegal immigrant. The bail applications therefore shall be adjudicated upon in terms of Section 60, Subsection 11A of Act 51 of 1977. I direct that the offences fall under Schedule 6 of the Act. I further direct that the bail applications shall be conducted in the regional court. Signed at Polokwane on the 9th of September 2024 by Advocate M.I. Tenga, Director of Public Prosecutions, Limpopo Division, Polokwane, as the court wishes. Your Worship, may the confirmation be received by the court and form part of the record.
Any objections by the defense?
No objection from the accused.
The confirmation,
Confirmation. No objection.
Confirmation. No objection.
the confirmation certificate by the Director of Public Prosecutions is then received and accepted into evidence as Exhibit A.
Furthermore, Your Worship, the state consulted with the defense with regard to the place and date where the bail application will be held. And we agreed that the bail application in this matter will be done at Polokwane Regional Court on the 2nd of October 2024, as the court uses. Therefore, I apply that the court refer the matter to Regional Court A at Polokwane on 2 October 2024 for bail application, and the accused are to be remanded in custody as the court wishes.
Zvinotaura nemupikisa ndichigara kutaura akataura kuti nguva yekupedzisira tatiri pano pamberi pedare mhosva yatomisa kuti imi munofanira kuti timutaurisane nevamiririri venyu, nokuti nhasi vari pamberi pedare kutaura nenyaya yebheili. Vakanzi nguva yekupedzisira dare rakatotora yakatotaura kuti mumiriri womupomerwa kutanga anofanira kuti apiwe statement zviri mukati medhoketi. Saka dare ratotenda kuti anofanira kuti awane statement izvi. Saka vakanzi dare rakanzi richapa mashoko kuti sei rakapa mashoko kuti mumiriri womupomerwa kutanga anofanira kutoti apiwe statement izvi, nekuti vakanzi nhasi DPP akatoti panofanira kutoti atenderani nazvo dare rakaita. Saka vakanzi vakatofaila nhasi clerk of the court pane tsamba vakaisa kuti dare rinofanira kutotaura kuti sei dare rakatotaura kuti mumiriri womupomerwa kutanga anofanira kuti apiwe statement. Saka vakanzi izvezvi havasati vatambira kana kutowana pinduro kubva kuyeapili vavakaita, nekuti vakatotaura nenyaya yebheili kuti nenyaya yebheili kuti pane zvavo zvatochinja, nekuti machenjero ako ndekuti DPP akatonyora tsamba yekuti inovasunga vatatu vatotaura section 60 subsection 11 capital letter 8 2 of 1977 kuti imwe vatatu muri pamberi pedare munotokumbira kuti musunungure nebheili. Saka mhosva matodzimira pamberi pedare ndi mhosva mbiri dzomwe ndi mhosva yekuedza kuuraya, mhosva dzekutatu dzekukurira kuguma kwekururamisira, nemhosva yekuwanikwa kuti risiri pamutemo nekuva nemabhara asina kunyoreswa. Iwe musungwa wechitatu une mhosva yekuti iwe uri kugara munyika inozvisiri pamutemo usina mapepa, nekuti nenyaya yebheili vatotaura kuti bheili inovara paspecial 6 and mhosva ichatonga muregional court. Vakanzi akatotaurisana nevamiriri venyu kuti nzvimbo nezuva kuti mhosva iyi ichatonga kana bheili ichatonga riri muregional court. Vakanzi mhosva iyi ichagara mupolokwane regional court musi we2 October 2024.
Your Worship, good morning. This is one of those instances where I truly don't know where to start because it's a bit of a mess. I want to firstly place on the record that as we currently stand here, the first time that I got any response from the EDPP since our previous court date was this morning in person. I would like to hand off an email as proof. I've got 2 copies here, where I CC'd the relevant persons of the extensive, let's say, steps taken in order to obtain who the relevant persons that might be dealing with the matter is, and no response has been received to date. I would also like to place on the record that it's my own opinion that the state is currently seeing that there's no formal procedures taken in terms of an appeal. They are still currently in contempt of a full court order. That is a fact of law. They have not complied, and they have not launched any formal procedure that stops their responsibility to comply to a court order. And that's quite concerning to me. It's quite concerning that the state comes this morning, they ignore myself and my instructing attorney, and then they simply just say, we've got our final instruction, we're going to do an appeal. So that's something I would like the court to reflect upon. And I would like the court to give us an indication of if this is the modern era and the Constitution applies, how can this be allowed? It's a direct and complete contravention of the constitutional rights of the accused. And secondly, it's a complete contravention of the statutes that regulates this court. If the court says you do something, you do something. There's procedure that's in place that allows you some leeway. But none of that has been followed. That is a fact. Now, I've got a second issue. We've now heard on record that, and just to take a step back, the court made a ruling that in terms of the relevant section of the Criminal Procedure Act, the accused, it's an interest of justice for the accused to have access to a statement that he made himself. That is a common fact. You can all agree on that. Now, we just gave an indication, my landlord advocate Childcare said on the record that they're going to appeal a ruling of the court based upon section 65, if I'm correct. Now, I would like to read into the record section 65. It says, appeal to Superior Court with regard to bail. Subsection 1, subsection 8 reads, and I'm going to read it slowly because it's very relevant, because in the end, I will argue this morning that there is no grounds for an appeal at all. Because the statutes, the fines application does not make provision for same. It reads as follows, subsection 1, subsection 8. An accused who considers himself aggrieved by the refusal by a lower court to admit him to bail, or by the imposition by such court of a condition of bail, including a condition relating to the amount of bail money and including amendment or supplementation of a condition of bail, may appeal against such refusal or the imposition of such condition to the Superior Court having jurisdiction or to any judge of the court if the court is not then sitting. So what is important from this section? It doesn't apply because the state cannot act in terms of this section. The accused, it's very specific. So the question is now, what can be appealed? A final decision being a refusal by a lower court or then by implication a condition of bail. So now section 65 capital A is also very relevant, and it's appeal by Attorney General against decision of a court to release accused on bail. Subsection 1, subsection A reads, the Attorney General may appeal to the Superior Court having jurisdiction against the decision of a lower court to release accused on bail or against the imposition of a condition of bail as contemplated in section 65, subsection 1, subsection A. Alright, so it is my clear submission that the state has no grounds to take this matter to another court on what they want to do. They want to appeal a ruling of this court based only solely upon the fact that the court granted us access to a statement. There's no final decision has been made. Section 65 and section 65 capital A does not find application. I've got in my hand here, it's always nice to have a handbook ready. It's a book, it's a third edition of Bail Practitioner's Guides, and it's always good to read it. Where very clearly it is stated and confirmed that the state cannot do what they want to do now. It's not physically possible. It reads as follows. In terms of section 65, subsection 1, subsection A of the Act, an accused who considers himself aggrieved by the refusal by a lower court or by such court imposition of a bail condition may appeal against the magistrate's order. It is submitted that the precondition for the lodging of an appeal is entirely subjective and amounts to no more than the accused desires to appeal against the lower court order. And this is now very important. However, such right is limited by the circumscription of the circumstances in which it may be exercised. Bail appeals are competent only against the refusal of bail or against the nature or ambit of a bail condition. And then we are referred to section 65 of our reading to the record, and in the case of S versus Bengu, 1995, and S versus Renz, 1996. This is tried principles. I could not address the court previously on this fact because there was no formal indication that the state would proceed with the supposed appeal. But, Your Worship, unfortunately, I cannot stand here and just allow the state to dictate proceedings in terms of a supposed section which finds no application. It would be completely incorrect in law for the state to approach. There's no valid basis for this. So unfortunately, yet again, I believe I'm going to put the court in a position to make a ruling on that. And I would just like to place on record, I have no intention to ambush the state or my opposing counsel in this matter. But the fact of the matter is, if they responded at all to any of my emails or to any of my inquiries, we would not be in this position because then I would be in a position where I would formally file heads and I would have formally filed, given a chance for the state to prepare on this. But the fact of the matter is they are completely wrong. As the court pleases.
Advocate Chauke, response.
All right, live visuals there coming out of the Mankweng Magistrates Court. That's where the bail application, at least what was meant to be that, of 3 men accused of murdering 2 women in Polokwane before feeding their remains to pigs. Those are the claims. That bail application is taking place inside the court, but a spanner in the works has been introduced, as is the case with many of these cases. Part of what we're hearing now, well, perhaps I should take you back. The last time we were in court, there was a request made by defense for accused number 1, who asked for the statement that the suspect actually wrote to police to be furnished to them, essentially to have access to what was said. The state, I beg your pardon, yes, the state was against that decision, but however, the court granted it nonetheless. As a result, the NPA is trying to appeal that decision and is asking that the case be moved to a different court for that particular interlocutory application to be heard. And what you just heard now is accused number 1's lawyer pushing back against that, saying what the state is trying to do cannot be allowed to happen. These things typically get technical. What you need to know, though, is that we are yet to get to the merits of this actual case itself. As I've said now, we're still going through those bail applications and the wrangling in between, so to speak.